Okay, we are ready to start. It's my pleasure to introduce Alon Harel. He's the Mizrach Professor of Law and in at the Hebrew University in Jerusalem. Happens to be my alma mater too.
And we owe him money.
Yeah. They still owe me money. And he the author of Why Law Matters, and oh God, I've just forgotten the name of the
Reclaiming the Public. It just
Reclaiming
came
the Public.
about 2 months ago.
And he'll be navigating the tension between constitutionalism and democratic majoritarianism. The role, and the subtitle of the talk is The Role of Institution-Dependent Goods in Liberal Democracy.
Thanks. It's a very fancy name. I'm not sure the paper is as fancy as the name is. Further, I'm very happy to be here. As I think many of you know, I was the first fellow at the Center of Ethics many years ago, and Melissa was the head of the center. So I'm very happy to be here again. Nothing changed. It looks the same, including the poster, the famous poster. The doors. Yeah. I'm going to talk about a subject that I think many of you think that there is nothing new to say about it, but I do my best to say something new about it. It's a joint work with Avichai Dorfman, who is a professor at Tel Aviv University, who regrettably is moving to University of Texas next year. I'm going to talk about constitutionalism and the relation between constitutionalism and democratic majoritarianism. And this, as at least the lawyers know, but I think others as well, this has been at the center of attention, both among scholars and among scholars of constitutional law, and also among judges, the public, and so on and so on. Why are courts so important? Why do they have the powers that they have? Do they intrude unjustifiably on democratic politics by making decisions which should be subject to formal and informal democratic or majoritarian processes of decision making? In a previous article, we maintained, Avichai Dorfman and myself, that this conflict can be conceptualized as a surface manifestation of a broader idea that all liberal democracies are subject to basically a normative trade-off between two types of demand: constitutional demands and statutory demands. In this essay, we maintain that both constitutional provisions, norms that are not dependent on our contingent choices, elections, referenda, whatever, and statutory provision, namely norms that are contingent on our choices, preferences, or judgments, are necessary features of liberal democracy. We make the argument that there are institution-dependent goods, namely those goods that depend on the institution that created them. So when you have a norm that was created by the legislature, it provides you different goods than the ones that will be provided, that would have been provided had it been done by legislatures. Some goods depend for their very existence on being produced by certain institutions and not by others. The institutions that brings the norms into existence communicate the status of the norm and thereby determines its value. Hence, individuals sometimes have an interest that the legislature will legislate a norm protecting their rights, or that the constitution will be the one that protects their rights. So they have an interest in having a statutory norm rather than a constitutional, or a constitutional one rather than a statutory one. More specifically, we established that the constitutional form of lawmaking is necessary to convey public recognition that certain norms are, such as fundamental rights, are binding independently of our choices. The value of these norms rests on the shared commitment to see them as not being subject to our choices. This is part of why they are valuable. Hence, majoritarian participation, in a way, undermines rather than reinforces their value. By contrast, the statutory form is necessary to publicly convey the recognition that certain norms provide values whose value depend on our choices, namely on our having decided upon them. To give you an analogy, which is not a good analogy, but I still give it. If I owe somebody money, I should give it as a debt. If I say, here is $100, but I don't owe you anything, I didn't fulfill it. It ought to be given as a duty. What we are doing is, in a way, importing this intuition that some acts their value depend on who makes them, why they're being made, what the deliberation that underlie the act, and we import it into the institutional context. Now, I say immediately, this is not a good analogy, but it is helpful at this stage to explain it. I don't use it in the paper. We establish, therefore, that institutions are not merely vessels through which norms get public recognition. In other words, when different institutions enact identical provisions, say everyone is entitled to X, they may nevertheless produce different norms and provide different goods. Another way of saying it, that some of the goods that legal norms provide are institution-dependent goods, namely goods whose effective provision depends on the institution that brings them into existence. This view, we argue, and I'll show it later, has a quite interesting, I think, doctrinal implications, because it means that if I get something from the law, I can still come and say, no, I want it through the Constitution, or vice versa. So, for instance, when Justice Scalia, and I'll talk about it a bit later, says, oh, I'm not against same-sex marriage, just bring it about through electoral means, then I would say, no, to bring it by electoral means is not the same thing as bringing it constitutionally. It's not the same good. Constitutionalism understood here, and here I copy from my book Why Law Matters, as a scheme characterized by the existence of binding norms constraining the legislature. The overriding force of constitutional norms gives rise, as we all know, to the problem of legitimacy. Given that decisions are considered legitimate if they are based on democratic systems or majoritarian systems, constraining the legislator is often considered as illegitimate. This is perceived as an infringement of the right of citizens to govern their society. How do we justify it? And there is a large section of the paper, I'm not going to discuss in great detail, that says what people did and how people previously justified. And the typical justification is saying something like this. It's basically established that constitutions bring about contingent desirable consequences that are unlikely to be brought about by other lawmaking institutions. For instance, they protect rights, or they protect certain procedures, democratic procedures. Despite the differences between these theories, they all share the view that constitutionalism is a contingent feature of the just legal system. In other words, it is a byproduct of the fact that without constitutions, we will get bad decisions, undesirable decisions, unjust decisions. Those can be either because they violate substantive rights or because they violate certain procedures. It actually doesn't matter, but this is contingent on the fact that without constitution, we will have a system that will bring about bad decisions, and therefore we have to have constitutions. This is the argument. Now, what we argue is the way to regard it is that the constitutional procedure is a mere means to bring about the decisions whose value is specified apart from the procedure that brought it about. We believe that this approach fails to account for the distinct value of constitutional norms in particular constitutional rights. What characterizes the traditional approaches is that the justness or the value of rights does not hinge on whether such rights are statutorily or constitutionally entrenched. It is this assumption which we challenge. Let me provide an example. The 13th Amendment of the US Constitution, prohibiting slavery, is prohibiting slavery. Slavery is, of course, not a very desirable system. I think most of us will agree about it. But it is important and was important for the founders of the Constitution to say not only that it's a bad to have slavery, it's bad that we even have the right or the liberty of establishing slavery. So we want to convey the understanding that the prohibition on slavery should not hinge on the preferences or judgment of citizens. Often institutions and procedures are constitutive of the good brought about by the norms they create, so that the norms lose their value if created by other institutions. Now, assume we believe that a norm is desirable norms, and we have good reason to bring it into account. We want to legislate a norm. Why should we care whether it's done by the court, legislature, our will, participation? To answer this question, we basically divide the discussion into two parts. With respect to, first I discuss constitutional norms, and then I discuss statutory. With respect to constitutional norms, I can think about three justifications. One is just the justification I provided, namely what can be called institutional instrumentalism. It is grounded in skepticism whether we should care about it. Depending on context and circumstances, it is perfectly sensible for right holder to remain indifferent, at least in principle, as to whether the right is constitutional or not. By contrast, there is a majoritarian view. And the majoritarian view, we should prefer statutory to constitutional because they reflect governance and so on and so on. And this is perhaps the majoritarian theory or the claim that majoritarianism is preferable, of course, on the condition that it leads to right results. I'm going to cite Justice Scalia in the same-sex marriage case, Obergefell, and he says, in a minority, he says, win or lose, advocate for both sides of the debate continued pressing their cases, securing the knowledge that an electoral loss can be negated by a later electoral win. So that theoretically, we have to prefer, at least prima facie, we have to prefer majoritarianism to a system of constitutional norms. The third approach, which obviously is our approach, naturally, rejects both institutional instrumentalism and majoritarianism, and insists that the institution that brought the right into existence is important. Suppose that instead of entrenching the 13th Amendment prohibition on slavery, every state legislature prohibits slavery. Receiving such broad affirmation implies that the society will be, let's say, a slavery-free society. The right reflects the choice or judgment, and this is a problem. The right reflects the choice or judgment. In other words, they implicitly assert that they could have decided otherwise. They could have instituted slavery. They don't want to. They will not want to. There's no chance that they will. But there is a kind of underlying premise that they can do it. What people in this society necessarily miss is not the security of living in a slavery-free society. We can assume that public opinion strongly disapprovative and so on and so on. Instead, the problem lies in the inability publicly to share the recognition that a slavery-free society is good, partly because its existence does not depend on what members of the society deem preferable or just. Democracy becomes very appealing if the right not to be enslaved does not depend on what we want or what we judge to be the case. And the independence of these rights of public sentiments is publicly recognized as such, and labeling it constitutional is a means by which we label it as such. Notice that the constitutional right must have the following two elements: obligation and public recognition. First, the right and the good it is designed to provide turn on what reason broadly construed rather than choice demands. That said, we can have many obligations that are not constitutional. What is crucial is a second aspect. And the second aspect is the public recognition of the right's obligatory nature. It is something we all share and publicly share by making it a constitutional provision by virtue of being members of the political community. A constitutional right not to be subject to slavery places a demand that is recognized by the state as one that does not depend on contingencies like what we want, what we judge to be just, and so on and so on. In the absence of constitutional entrenchment, protecting statutory rights may not convey the public recognition. The protection of these rights is then naturally attributed to the legislative judgment or inclinations, and not necessarily on its duties. Even if all members of the legislative assembly or body solemnly declare that it is necessary that we have prohibit slavery, the explanation or the account they give, the grounding they give, is subject to challenge by tomorrow majority. Public recognition, a constitution is a convention by which we convey this in a way that is not challengeable by future majorities or in elections and so on and so on. Why is it so important to have it? And there are two different answers that I want to discuss here. The first answer is that these rights ensure that democratic participation arises between free and equal citizens, while the second suggests that constitutionalism provides us or enriches the discourse by enabling us to discuss the question of what the grounds are and to make statements about it. In other words, it enriches the discourse of democratic polities by providing a clear distinction between those decisions that are being made by virtue of the fact that we want them or judge them to be just, and those decisions that bind us independently of our will. In other words, in a way, this enriches democratic discourse in ways that make it, at least if you think about democracy in more holistic terms, much more democratic, because we don't only discuss what norms are desirable, we also discuss what the grounds of these norms are. Majoritarian process raise a concern about the terms of the interaction between participants. Part of democracy value depends on the justness of these terms. Democratic participation that allows, even in principle, for the exclusion of some members of the political community, treats them as inferior to others. This is so even if the legislature chooses not to use its power to exclude or to treat people as inferior. Hence, democratic participation calls for just terms of interaction which do not hinge on majoritarian processes. Constitutional rights are necessary for such terms to count as just. So we can speak about two layers of norms. Constitutional rights form the basic layers, whose purpose is to ensure that all citizens participate in democratic lawmaking as free and equal persons. Right of free speech, for instance, another constitutional right, fix what can be called a mandatory floor of entitlements that are not subject to the control of governments or citizens. Having them independently of the choice of others ensure the status of citizens as equal and free. Only then can they manifest the liberalism two pillars, freedom and equality. So under this view, it is not enough to give us freedom and equality subject to our choices, preferences, or judgment. Instead, being free and equal should publicly be recognized as a structural feature of the political system. Our fundamental status as free and equal persons cannot be assimilated into the majoritarian processes of decision-making. It is a precondition for the legitimacy of the political authority. Its constitutional status is the institutional means by which it manifests public recognition. So this is the first part. The second part is what its contribution or enrichment of the political discourse. So the existence of constitutional rights enable a source of deliberation that cannot exist in majoritarian system. We may protect a right effectively without deliberating in majoritarian system. We just ask, is it good or is it bad? We don't have to decide or acknowledge whether we have a duty to do it or whether we are permitted to do it. It is not necessary because the statutory right typically does not convey what its grounds are. So when the legislator decides on a particular norm, it doesn't decide what the grounds of the norms are. And people can differ as to what the grounds of the norms are. Thus, the coexistence, on the other hand, if you have a constitutional norms and you debate as to whether these desirable norms ought to be constitutional or not, you are making a very different judgment. The judgment that includes also the claim that we are not free to transform it. Thus, the coexistence of constitutional and statutory rights provides a variety of institutional mechanisms for deliberating about rights. It broadens rather than narrows the scope of democratic political discourse by providing an opportunity for signifying what the grounds for the rights are and what its status is. Rather ironically, our account of constitutional rights is a perfect inverse of the commonly held justification of these rights. The commonly held justification says that we make constitutional rights such that it will be difficult to amend them. To prevent them from being easily amended, we prevent them from being amended. That's a task. Under our system, it's just the opposite. By making them not amendable or not easily amendable, we mark them as nearly unamendable and stress the fact that their binding force arises independently of our choices. So while what we think about is let's make them unamendable because we want them not to be amended, here we want them not to be amended in order to stress what they stand for and what their role in political discourse is and so on and so on. Their status as constitutional constitute public recognition of their binding force. So far, I talked about constitutionalism. Now I want to turn and to discuss the necessity of majoritarian decisions. In justifying constitutionalism, theories often point that democracy may prioritize interests of majorities over minorities or vice versa. This concern is a contingent one, as it hinges upon the decision majorities make. To the extent that majorities do not abuse their power, majoritarianism can be satisfactory. We establish so far there is a deeper concern. The rights of individuals in majoritarian system are by definition contingent on the judgment inclination of the majority. Even if this will never be realized, even if the majority protects these rights vigorously, it is still the case that the protection hinges on the choice and discretion rather than on duty. This is a non-contingent deficiency of majoritarian institution. Even if the legislature is sufficiently enlightened, fully devoted to the protection of rights and justice, the mere fact that rights depend on our choices is a deficiency that can be addressed by entrenching constitutional directives. Sorry, what I said earlier was wrong. Now I focus on democratic majoritarianism, on the goods of democracy and majoritarianism. Constitutional entrenchment publicly conveys a shared recognition that there are obligations that bind the polity and are not dependent on its contingent choices. By contrast, statutory norms are norms, I will argue, at least sometimes, not always, whose legitimacy, at least in part, rests on the choices of the public. As with norms that belong to the Constitution, by virtue of the fact that the goods that they are designed to produce hinge on their status as statutory, hinge on the process by which they are being brought, these majoritarian goods. More specifically, what characterizes the statutory process is broad public participation on the basis of what the participant taken severally choose, prefer, want, or judge to be just. It is this feature which sometimes, not always, sometimes, make the case for statutory lawmaking as the appropriate process. Now, I have to admit, sometimes we want statutory process for other reasons. We want statutory process sometimes because the public make better decisions than other systems. We may want it because we want it on the basis of freedom and governance and free governance. But I think there are some cases, some norms that are also statutory norms that are also institution-dependent goods. The goodness hinges upon the majoritarian process. It is this later category that is of interest to us. In such cases, the statutory decision-making, particularly its choice foundation, transform the good. The fact that we choose them transform the good that is being provided by them. And let me use an analogy. Marriage. Marriage has been transformed radically. In illiberal societies, there is, or many illiberal societies, there is arranged marriage. In contrast, marriage in liberal societies is based on voluntary decisions of the couple, at least under pressure of other things, but anyhow, overall, the idea is voluntary decisions of the parties. I do think, and I read a little bit around it, the literature around it is fascinating, but it is obvious that, it's obvious, the way I would articulate it, the goods provided by marriage have changed. In other words, the good that was provided by marriage, arranged marriage, was stability, fitness between the couple, often class fitness or economic interest and so on. And the voluntary, you can assume, it's kind of love and passion and whatever. Marriage, in particular, what counts as successful marriage, is perceived differently, so I argue, in a society where the decision to marry is governed by the couple rather than by the parents. We may say that while there is some overlap between marriage in this society and this society, there are also fundamental differences between these institutions, such as the goods, or may I say the goods and the bads provided by these institutions, differ. We believe that this analogy carries some relevance to the political sphere. There are norms whose nature and value hinge upon the statutory process. In such cases, a certain statutory process of lawmaking is what accounts for the value of the norm. Now, this is at a very early stage of thinking this part. But here, the example that I provide here, and maybe you can attack this example, is taxes. Connection between taxes and statutory decision-making based on consent is widely recognized. Slogan, no taxation without representation. I know that you Canadians exist just because you didn't agree with this, but anyhow, this is obviously a famous statement. These observations indicate the process of legislation, particularly the ability of the public to convey their preferences and judgments through this process, is a necessary feature of the legitimate states. And here again, there are three different accounts that purport to justify why taxes ought to be done by the public: instrumental, a right-based one, and institution-dependent one. According to the instrumental one, we make decisions because they are more likely to make better decisions. For instance, according to the Federalist, an authoritarian rule may subject the people to continual plunder. That's the term that they use, continual plunder. If the people don't decide, then others will just take their money. The rights-based interpretation, defended by Locke, believes that consent is necessary to protect the fundamental law of property. These interpretations are often invoked to justify the requirement that levying taxes require public participation, which can be realized by a statutory process. Without detracting from the importance of these accounts, maybe I will detract from their importance in a later version, but at the moment I don't want to detract. We argue that by using statutory procedure aimed at eliciting consent to the levying of taxes, the very nature of the good produced by imposing taxes is transformed. Surely we can provide public goods and redistribution by an enlightened monarch. Yet there is a fundamental difference between the enlightened monarch rule and a system based on the consent of the governed. Only the latter system can turn the goods that are being produced to being our goods once we create, and so goods for which we are responsible. If there are people here from social sciences, you probably know the concept of warm glow. Somebody knows this? Warm glow? No? Psychologists have done a lot of work. Sometimes we care that certain result be brought into existence. Sometimes we don't care that only that certain result will be brought about into existence. We want them to be brought about by us. That's the important thing. Yeah? That's the joke about a nurse that was in Africa was treating leprous people. And people told her that maybe there will be a cure to leprosy. And she said, this is horrible, we cannot help them then. And it's indicative, because what she wanted is to help the leprous people, to make it the case that they will be cured, not that they will be cured, but that she will make it the case that they will be cured. And sometimes it's important for us to have goods that are produced by us. These goods are not merely goods that are bestowed on us, but ones that we created, and therefore goods for which we are responsible. Participation turns citizens from mere beneficiaries of the goods to agents who have measure of control over them. Hence, precisely as there are norms that are in principle constitutional, conveying the shared recognition that the goods they produce are not based on our will or consent, so there are goods whose value rests on the fact that they are based on our choices. Such norms lose important constitutive aspects of their value by failing to reflect our choices. I will skip a little bit. I think 5 more minutes?
Yeah, even 10.
Oh, yeah. If it's 10, it's fine. Constitutional rights, as we argued, reflect the public recognition of the right's obligatory nature. The provision of the good does not exhaust the possibility and desirability of grounding these rights in our choice also. And this is a doctrinal aspect that I want now to show what implication it has for law. I know philosophers are less interested, but I'm actually interested also in showing the doctrinal flesh that it has. So let's say we have a statutory norm and it's based. We still may want to have the constitutional norm. Doing so convey the recognition that it should not depend on our choices. And if we have a constitutional norm, we may also want a statutory norm. They do different things. Constitutional right to same-sex marriage can also receive public recognition by enacting a statutory norm furthering or promoting constitutional right to the same. Isn't it unnecessary duplication? So we have a statutory norm, we have a constitutional norm. Why do we need another thing? Moving beyond pragmatic consideration, the argument established that identically worded norm produce qualitatively different goods. depending on the lawmaking institutions. To this extent, having a constitutional right to same-sex marriage and a statutory right to the same are not an instance of duplication. Rather, they may at times produce two different goods. Further, and we get to the main point, they enhance rather than dilute each other's significance. The re-entrenched right suggests that we are not only duty-bound to respect it, as the Constitution says, but that it is also our choice. Now I come to, and that I wrote yesterday, and I wonder whether it works. To complete the analysis, we should also consider the possibility of conflicting statutory and constitutional norms. So in the United States, after they had Roe versus Wade, many prohibitions on abortion remained on the book. So, now, of course, now they changed Roe versus Wade, so I'm not going to expand on it, but they remain on the books. Let's say they remain on the books and they are inoperative because the court decided they are unconstitutional. This law remains dormant for many years. I do not claim that they are just or desirable, because if I claim I'll be killed in a liberal society, and maybe justifiably so. I'm not claiming. But I do maintain that in general there is value in the coexistence of inoperative norms. The coexistence shows that yes, we have an obligation not to prohibit abortion, but we want to prohibit it. That's our choice. There is something in it that is not a duplication. It's not a duplication. It's something that conveys a certain message. This essay develops the notion of institution-dependent goods. We've argued that the institution in charge of producing norms should be assessed not only by reference to their contingent contribution to the creation of good or desirable norms. Instead, that the institution that creates the norms is often necessary to bring into existence the good resulting from the norm. Legal norms are institution-dependent norms. The value hinges on the process by which they are created. Entrenching a norm in the Constitution marks the norm publicly as a norm whose soundness does not hinge on choices. In contrast, statutory norms are ones that indicate and highlight our actively daily participation and engagement with the norm. We do not deny, of course, that there may be numerous other pragmatic considerations that ought to guide us in selecting institutions that create the norms. We all know that the world of politics is a little bit more messy than philosophy. These considerations are often very important, yet recognition of the principle rather than mere contingent consideration can both provide a better account of how institutions shape our normative reality and carry moral and policy implications. I'll only say that I'm these days obsessed, as some people understand why, obsessed about the issue of constitution, the importance of constitution. So I may be totally biased with respect to my attempt to save constitutionalism from the forces that erode it in many, many countries, including in my country, but also in other countries. This is my attempt contribution to fight against populism and the idea that the people can make decisions now. Thank you very much.
So we have a five-minute break, and I'll be back at 5 to whatever that time would be, 5 to 5.